Hunger and Allen and another.
Lord Wilson will explain the decision of the court.
This case is about the circumstances in which a court will dismiss an otherwise valid claim on the basis that the claimant's own conduct related to it was unlawful. On 28 January 2007, when she was aged about 14, the claimant, Miss Hounga, was brought from Nigeria to live in the home of the respondent, Mrs. Allen, in Hanworth, Middlesex. Miss Hounga, who was illiterate, had been living with Mrs. Allen's brother in Lagos. The Allen family arranged for Miss Hounga to come to England on false pretenses. One pretense was that Miss Hounga was aged 20. Another was that she was the granddaughter of Mrs. Allen's mother, who also lived in England and whom Miss Hounga was supposedly intending to visit. Miss Hounga was aware of these falsehoods and went along with them. The result was that she was granted entry to the UK on a visitor's visa valid for 6 months. She knew that she had no right to remain in the UK after 28 July 2007, and that, as a visitor, she had no right to take employment. In the event, however, Miss Hounga remained in Mrs. Allen's home until July 2008, and the two of them entered into a contract of employment under which Miss Hounga was to help to look after Mrs. Allen's children. In breach of promises which she had made to Miss Hounga, Mrs. Allen neither paid any wages to her nor sent her to school. Indeed, at times, Mrs. Allen was violent towards Miss Hounga. She also threatened Miss Hounga that if she left the house, she would be sent to prison because her presence in the UK was illegal. On 17 July 2008, Mrs. Allen pushed Miss Hounga out of the house and locked the door. Someone found Miss Hounga and took her to social services. In that way, therefore, Mrs. Allen dismissed Miss Hounga from her employment. In so doing, she also discriminated against Miss Hounga on the grounds of her Nigerian nationality, for this had led Mrs. Allen to conclude that she could dismiss Miss Hounga with impunity in the light of her unlawful immigration status. In these circumstances, an employment tribunal held that, in discriminating against Miss Hounga by dismissing her from her employment, Mrs. Allen had acted in breach of Section 4(2)(c) of the Race Relations Act 1976, and it ordered her to pay compensation to Miss Hounga of about £6,000. But the Court of Appeal set the order aside. It upheld Mrs. Allen's defense of illegality, namely that it was not open to Miss Hounga to complain about dismissal from an employment which she had agreed to take and which, to her knowledge, was illegal. This court unanimously allows Miss Hounga's appeal and restores the order for compensation. All 5 members of the court agree that there is an insufficiently close connection between the illegality of Miss Hounga's entry into the contract of employment and the acts by which Mrs. Allen unlawfully dismissed her. That would have been the basis on which Lord Hughes and Lord Carnworth would have rejected Mrs. Allen's defence of illegality. But Lady Hale, Lord Kerr, and I prefer to reject it on a different basis. We consider that the defence of illegality rests upon an aspect of public policy, namely that the integrity of the legal system should be preserved, but that in this case, another important aspect of current public policy is in play, namely against the international trafficking of vulnerable people and in favour of protecting them. Application to the present facts of the definition of trafficking in a UN protocol signed in Palermo in 2000 suggests that Mrs. Allen and her family were guilty, or at least very close to being guilty, of trafficking Miss Hounga from Nigeria to the UK. Lady Hale, Lord Kerr, and I hold that it would be an affront to current public policy against trafficking to allow Mrs. Allen to evade liability to Miss Hounga by reference to the illegality of the contract of employment entered into between them.